We just watched a piece of tape where Erica Stefanko decided not to testify. Now, that decision came after she initially said she didn't want to testify, then during the trial at some point decided she wanted to testify. And then this whole sort of drama played out where her attorney mentioned to the court she wanted to testify. The judge gave her more time, told her again about her Fifth Amendment right, gave her time over lunch. And I almost felt like, DeWitt, at that point, you had two folks, the judge and the defense attorney, putting pressure on her not to testify. And maybe that's why she changed her mind. Was it overkill there, in your opinion?
I don't know that I would call it overkill. Obviously, it had some effect. And Ms. Stefanko, felt at some point, I guess, the need to give her story and have her story be heard to the jury, as do most folks who are involved in any litigation, whether it be criminal or civil. But I think it was very prudent upon the court and her defense counsel, especially considering what we've heard from Ms. Easter about the potential for cross-examination that would have come had she actually taken the stand. So I don't know that I would call it overkill. I think the defense was being prudent and diligent in making sure that he gave her the best opportunity at winning this trial, which was a tough case for the defense to win.
You know, you look at this case and you realize that perhaps she wanted to testify. She had to be talked out of it. You're a defense attorney. You have a client that wants to testify. You talk them out of it, knowing it's the right decision. I'm not questioning the efficacy of that particular decision. But still, you have to look them in the eye after there's a conviction. What is that like for a defense attorney? And that conversation saying, hey, we did what we had to do that would not have helped you at all.
I think as an attorney, you have to be frank with your clients and give them that frank and clear advice. And obviously, sometimes clients may have a disagreement with you, especially if the case doesn't turn out the way you expected it. But I would expect the defense attorney in this matter to let her know that he doesn't believe that her testimony would have helped any and probably would have resulted in this thing coming back even quicker against her and or even with more counts against her. So I wouldn't expect him to shy away from that. And if it is some sticking point between some discord and or satisfaction with the defense that she had, I think, she's probably misunderstanding the way the courts and trials work, which most folks do. That's why they hire us.
Right, and that's really the problem, is that a lot of people really don't quite understand. And I think that extends also into the jury box as well, where people sometimes just want to hear from the defendant. They want their story, no matter how many times you tell them they don't have to. That is not something that can be held against them. I think probably in your experience, sometimes it just doesn't work out that way.
That is right. That's right. A lot of times, actually, it doesn't work out that way, and the defendants don't take the stand. And just for the reason that we spoke about a little bit earlier, and as I said before, that Miss Easter alluded to a little bit earlier, that if Miss Stefanko would have taken the stand, that there would have been some recordings of conversations between her and Mr. Cobbs related to this killing, which certainly probably, or I should say probably, would not have played well with the jury. And there's a lot of speculation that goes on between jurors and or defendants. But, we have a certain training and reasonability and experience beyond their speculative, ideals. And, it's our duty to make sure that we advise our clients of those potential outcomes.
Yeah, and I'm glad you said that about those phone calls, because that's a perfect example for our viewers who are wondering why we're always saying it's not a good idea for defendants to get on the stand and tell their story. Now, we don't know what was in those phone calls, but chances are whatever was in those phone calls was not going to help her and probably would have ended up hurting her. And I also find that when you put your client on the stand, it shifts the burden. Now, not technically, but all of a sudden, rather than being about what the prosecution can prove, it becomes, do we believe that defendant?
Absolutely. It becomes a laser beam focus on the testimony of Ms. Stefanko at that point, if she does take the stand. Now, I'm not sure if she would have taken the stand if they would have kept her in a mask. I think that obviously plays some part in the way jurors are going to view her, whether or not you can see facial expressions. Of course, the eyes are the windows to our souls, and you can tell a lot of things by that. But certainly, I think all of us can probably come to the conclusion that it's necessary to see somebody's mouth too when they're communicating with you. And maybe that would have had some effect on even the believability and reasonability of her testimony. But given that there seemed to be some really hurtful and harmful material that the prosecution had in their possession that would give into cross examination, they probably made the right choice by keeping her off the stand.
You know, you mentioned the masks on potentially on Erica Stefanko. You know, I've been very critical throughout. We've done a couple of trials now since they started getting going again. And I understand the need to continue. The wheels of justice have to keep rolling along. But I just feel like as a defense attorney, it would be so difficult to try these cases with masks on. I mean, we've seen some cases where they've had these shields that you can actually see through, which I think are so much better. But with the masks, I mean, as someone who tries cases, I mean, what are your feelings on some of these limitations that are brought about by this COVID-19 crisis?
I think it really works to take the emotion out of cases, and that can play to either side depending upon what they plan on, what the prosecution and the criminal litigation plans on basing this prosecution on. Either some emotion of these calls in this case between Stefanko and Ms. Cobbs, Mr. Cobb's mother, or emotion of the way she may have treated the minor GC, and without the mask, without being able to see somebody's mouth and facial expression, it kind of takes any emotion, maybe even away from that. And it makes it, in my mind, a very clear cut and dry evaluation of evidence, which is what a jury is supposed to do. But as trial attorneys, we know that we bring theater and emotion into courtroom because these things don't happen in a vacuum. And there are situational and emotional additives that get added into any story. And so I think it really favors an emotionless trial when you have masks and or barriers that kind of separate folks from the jury. And that can be problematic for defense attorneys. And I think it was in this case.
Absolutely. I could not agree with you more. All right, DeWitt, I want you to stand by. We have a lot more to discuss. Right now, we're going to take a quick break. And on the other side of this break, we're going to have more reaction to the verdict in Ohio versus Erica Stefanko.